Awesome, thank you. I'm gonna go ahead and share my screen. Okay, y'all can see the presentation view? Perfect. Okay, so I am so excited to be here presenting to you all today and talking with you all. Thank you for inviting me and all of you for showing up. A little bit about myself. I'm Sarah Duhart Clarke. I have my PhD in applied social and community psychology. And this study was actually my dissertation. So I'm extra excited to present on it because it means that my dissertation is going beyond just my defense. So in grad school, I focused a lot of my work on criminal legal system reform efforts, such as improving indigent defense systems and also pretrial practices. Now that I've graduated, I'm working as a research public health analyst at RTI International, and I'm still doing criminal legal system reform research, but I'm also doing some focusing on drug use behaviors, harm reduction strategies, and kind of the individual and community level impacts of criminal legal system practices. So today I'm going to present to you all a systematic review and meta-analysis of defendants' criminal justice related outcomes. Feel free, like he said, to ask questions throughout. I don't think I can see the chat very well because I've got so many things going on my screens, but I'll try to keep an eye out, or feel free to speak up, but there will also be time at the end if you want to wait till then. So before I jump into everything, I've got some people I want to acknowledge first, and I think a lot of them are on the call today. So Eva McKenzie, Bailey Kurtz, and Samantha Zatola all helped me with this meta-analysis. If you've ever done a meta-analysis before, you know you cannot do it alone. Even just for inter-rater coder reliability and all that, you need multiple people. But also this ended up being a very big lift. We looked at a lot of studies, we did a lot of coding, we read a lot of full text, and so I could not have done all this work without the three of them, especially not in the time frame that we had to do it. And Sarah Demaray was my advisor throughout grad school, so I also would not have been able to do this work without her. Her guidance and her expertise really helped shape all of this. So first I'll start with some background, and I'm not going to spend too much time on this because I know y'all do research in this field or work in this field, so I don't think you need a lot of background on this, but just to kind of like situate our context of what we're talking about today. So the vast majority of people involved in the criminal justice system are unable to afford their own attorney and thus have one given to them, i.e. indigent defendants. The right to counsel is covered under both the 16th and 14th Amendments, and the 1963 Supreme Court case ruled that even when people are unable to afford counsel, because it's a fundamental right to fair trial, they must have counsel given to them. That being said, as you all know, state and local jurisdictions vary in their implementation of indigent defense systems. So even though this is a federal right, it's implemented differently in different areas. Despite high proportions of indigent defendants and over 50 years of legally mandated indigent defense services, there's still a lot that we don't know about outcomes for people with indigent defense counsel compared to those with retained, or differences among types of indigent defense counsel. So for this study, we defined two main types of indigent defense counsel, which is kind of oversimplifying it, but these are the two main types that we defined. First is public defenders, who are defense attorneys employed by the government full-time and only take on indigent defense cases. And then assigned counsel, which is defense attorneys who work privately, but also take on indigent defense cases when requested by the court. Usually assigned counsel is granted if there's not enough public defenders to handle the current caseload, though some jurisdictions do only have assigned counsel systems, so that also kind of varies. One of the main differences between public defenders and assigned counsel is that assigned counsel typically have some ability to negotiate their compensation, whereas public defenders do not have as much leeway to negotiate. And they also can make money working private cases, not just indigent defense cases. And public defenders have that kind of full-time role in indigent defense cases. So much of the legal literature that exists asserts that indigent defendants are disadvantaged in the criminal justice system, and a lot of these works cite attorney performance as a reason for this. One of the big ones that gets discussed a lot is high caseloads and lower pay, especially among public defenders. So because of high caseloads, people say public defenders may be unable to give cases the full attention they need to secure the best outcomes, or that because of low pay, that public defenders may not be adequately incentivized to provide best counsel. Another thing that gets cited a bit is the courtroom work group, which is referring to public defenders' full-time role in the court. And people on one hand might say that judicial decision makers are more familiar with public defenders than other defense attorneys, and thus may be more inclined to make decisions favorable to the defendant. Or on the other hand, there's also people that theorize that public defenders' allegiance may be with the court as well as with their client, and that split allegiance can also affect outcomes. But overall, there is disagreement about the outcomes that indigent defendants experience and the mechanisms for these outcomes as they differ by attorney type. So the gaps in our current knowledge that kind of led us to this meta-analysis is first, research on outcomes for indigent defendants is comprised of studies conducted in different jurisdictions. So it's not necessarily very cohesive, it's just unique to each place it was conducted. And studies that do include information about indigent defendants focus on outcomes for specific court stages or for specific stages in the court process, whether that be pre-trial, case disposition, post-trial, but it usually focuses on just one area. And then there's also disagreement among legal scholars and professionals about if and how indigent defendants are disadvantaged in criminal court. So all of this highlighted the need for synthesized findings and a better overall understanding of the research evidence that exists so far, which leads us to the current study. So the purpose of this current study was to synthesize current empirical literature on outcomes experienced by people with public defenders, assigned counsel, and retained counsel across court proceedings. So specifically, we conducted a systematic literature review and meta-analysis of the current empirical literature on pretrial outcomes, case outcomes, sentencing outcomes, and post-case outcomes for indigent defendants compared to defendants with retained attorneys, and also for public defenders compared to assigned counsel. So to do this, we followed the preferred reporting items for systematic reviews and meta-analyses, which is PRISMA. It's a pretty rigorous guide to conducting these kinds of studies. So we followed that to make sure that we were covering all our bases. We started with searching some databases with these search terms. We had 6 databases that we searched. We used all of these search terms. We also checked the references of the sources that we found to make sure we were getting everything. And we did all this up until December of 2020. So everything that we pulled had been published or put out into the world as of December 2020. Anything after that, we didn't capture in this. Our inclusion criteria, it had to include empirical data on outcomes for indigent defendants in criminal courts. It had to be conducted in the United States, and it had to compare outcomes across attorney types. So this means that the exclusion criteria was that it did not include empirical data on outcomes for indigent defendants. It was conducted in non-criminal courts, was conducted outside of the United States, only included outcomes for one attorney type. So that would mean that there was no comparison. They were just reporting outcomes for one attorney type. Or if it was a duplicate of another study that was already included, then it obviously got excluded. This, I know this text is very small, so I'll kind of walk through it. But this is just showing the overall process and what we reviewed at each stage. So we first started with those searches and those databases, and that was mostly just looking at the titles of things, and also if it was available, little snippets or partial abstracts, like when you search something and it gives a preview of it, we might have looked at that. But we definitely opted on being overly cautious. So we included anything that looked like it might fit into it. So in our search, we identified 592 sources, but 121 of those got excluded for being duplicates. So at the next stage, we had 471 sources that we read the abstract for, and we screened based on the abstract. At that stage, we then excluded another 226 because they didn't meet criteria, which left us with 245 to review the full text for, but we unfortunately were unable to find 3 of them. They were all, I believe, all 3 of them were just older dissertations. And so we just weren't able to get a copy of the dissertation from the library, either because they weren't willing to mail it to us or because there was no way for us to request those records. So 3 did get excluded for that reason. So we had 242 sources that we read the full text for, and excluded those for a variety of reasons listed right here, but largely sources got excluded because they didn't contain empirical data on outcomes for indigent defendants. So it was either things just discussing like why there might be discrepancies in outcomes, but didn't actually include like studies or empirical data on it. So that left us with 71 sources to include in our review. But in the data extraction phase, we had to exclude sources from the meta-analysis if they didn't have full statistical information required for inclusion, which I will go into a little bit more detail about that in the following slides. So at the data extraction phase, we had all of these sources and we pulled information from them related to like the study information. So like what type of publication was it? Where was it conducted? What were the data collection years? The sample and demographic information, any information that they gave about kind of the demographic makeup of the sample or anything like that. We coded for the comparison groups that were included in the study, which we collapsed into these buckets of public defender, assigned counsel, and retained counsel. And for some of the analyses, we actually combined these groups. So if studies had outcomes for both public defenders and assigned counsel, then when we compared any indigent counsel to retained counsel, those got collapsed into one group. And then we also coded for the outcomes and for the statistical results that they reported. So if sources didn't report the full stats needed for meta-analysis, so like one example is if the outcome was reported as like a mean, then we also needed the standard deviation in order to include it. So if the source didn't include the standard deviation in that instance, I tried reaching out to the authors of the studies. For a few of them, I was able to get full statistical information from reaching out to authors, but a lot of them, especially studies conducted more than like 10 or 20 years ago, people just didn't have that information to share anymore. So we started out, there was 4 of us coding, and we started out coding the first 3 studies together so that we could ensure that we were all on the same page, knew what we were doing. We independently coded 10 studies, the same 10 studies, so that we could test inter-rater reliability. And we got a score of 91%, which was really good. So we felt comfortable doing the rest of them independently. So the remaining 58 sources we coded independently. We did double check the first 20 just to be really rigorous and make sure everything was being done correctly, and we didn't really find any mistakes. So the rest of them were done completely independently. And since there were so many studies to keep track of here and so many coding sheets, we ended up using a Qualtrics survey where after we kind of coded the information, it got entered into this Qualtrics survey so that we could export the results into an Excel sheet to really help with the database construction. So going back to that, the original 71 that we found, regardless of the full statistical information, because we did extract the data from these. So the outcomes that we found in these 71, we kind of had these 4 main court processing stages. So for pretrial outcomes, we found pretrial release, so whether or not they remained in jail or released into the community. Bail amount was often reported. Transfer to adult court in juvenile case was reported in some studies. The decision to indict was reported. For case resolution methods and disposition, we had whether or not the case was dismissed, if it was resolved by plea, if it was resolved by trial, if the person was acquitted, if they were convicted, the conviction severity, which mostly refers to if they were able to get it down to a lesser charge. And then the case length, how long did it take from beginning to end to get it done? And then sentencing outcomes, we had sentence type, which was usually like carceral versus community, but also some of them broke it down by like jail or prison, which we collapsed those into carceral versus community just so that we could compare across studies. And then sentence length was also reported. And for post-case outcomes, we had appeals decisions and recidivism. So there was a lot that these 71 sources covered. But when it came down to just that last 40, so there was 31 that we had to exclude for not having full statistical information. We ended up getting rid of all of these ones that are grayed out, are outcomes that we weren't able to include in the meta-analysis because we didn't have enough statistical information to do so. So we ended up with only 8 outcomes. In pretrial, it was just pretrial release. In case resolution methods in disposition, the only one we had to exclude was case length. In sentencing outcomes, we excluded sentence length, and then all of the post-case outcomes, unfortunately, didn't make it into the meta-analysis. So like I said, we had 8 outcomes that we had enough information to include in the meta-analyses. For all of these, the outcomes were dichotomous, so they were yes, no, and so odds ratio was the chosen indicator of effect size for each outcome. And then with each one, we had 2 comparisons that we did. The first one was any indigent defense counsel versus retained counsel. So that's where I mentioned before, if a study reported both public defender and assigned and retained, for this comparison, we collapsed the 2 different types of indigent defense counsel into one. But then the second comparison we did was public defender versus assigned counsel. And so those ones we kept the 2 groups separate so that we could compare them, but we didn't include retained counsel in those comparisons. And then the moderators we included were geographic region, with the comparison being national samples. And then data collection start year was the other moderator.
Good morning, this is Carolyn Cooper.
So for our data analyses, we calculated the pooled effects with the odds ratios. The effect size values were weighted using inverse variance method. We conducted the analyses with random effects models. These are a lot of like technical jargony things that if you care about them, great. If you don't, feel free to tune this part out. We also assessed heterogeneity with Cochran's Q, I-squared, and distribution of true effect sizes. And then further assess sources of variance with meta-regression. So that's what those moderators were used for, was in the meta-regression. And then we assessed potential publication bias by examining the funnel plots of standard errors from random effects. For this presentation, I'm just going to go into detail for the interesting pieces of information. I'm not going to go into heterogeneity too much or publication bias because I don't think we care about that right now, but I do have that information if it is of interest to you. So for the results, I'm just going to go into the 40 studies that we had, which had 206 unique independent effect sizes. And I did recognize some of y'all's names on this call as studies that were included in the final meta-analysis, so which is exciting. And thank you all for including your full statistical information in your sources so that we could use it in the meta-analysis. So the years represented, we broke it down by decade for this bar graph, but when we used the moderator variable, it was just a continuous variable. But the data collection years spanned from 1962 to 2016, so a wide range of years. And as you can see in this, a lot of them came from the 70s and the 90s. Those seem to be the kind of big decades for doing this kind of research. Geographic regions represented, a lot of studies came from the Southeast. Over a quarter of the studies in this came from the Southeast. There was 21% that were national studies, but I do want to specify that doesn't mean that it was all defendants nationally that were included. It was just a nationally representative sample that they measured. And then the West, the Midwest, and the Northeast all had about 15%, and the Southwest had the least amount at only 8%. And I believe most, if not all of those, were from Texas. In study sources, a little over 40% came from peer-reviewed journal articles, also had a handful from government reports and law reviews, and then some dissertations or theses, and there was 1 or 2 books that were included in this. So the exciting results, this is going to be, I think, a lot of information at once. So I'm sorry if it gets overwhelming, but for pretrial release, so let me actually backtrack first. So the things highlighted in orange here are the ones that were statistically significant. So this comparison is the indigent defense, any indigent defense versus retained counsel. And so what this is showing for pretrial release, Indigent defendants were less likely to be released pre-trial than people with retained counsel. And that's because that odds ratio is less than 1. And so it's the same with case dismissal. Indigent defendants were less likely to have their cases dismissed than people with retained counsel. Indigent defendants were more likely to resolve their cases with guilty pleas than people with retained counsel. But interestingly, there was no significant differences in whether or not the case was resolved by trial. And then indigent defendants were less likely to be acquitted than people with retained counsel. And indigent defendants were more likely to be convicted than defendants with retained counsel. And then convicted of lesser charge, also not significant. But the strongest effect size we saw here was the sentence of incarceration. So indigent defendants were way more likely to receive a sentence of incarceration than people with retained counsel were. And I can go a little bit into these meta-regression significant covariates, but again, this might be a lot of information. But geographic region was consistently significant here, and it kind of varied on exactly how. So for pretrial release, studies conducted in the Southwest had significantly less differences in pretrial release rates between counsel type, whereas studies conducted in the West had significantly higher differences in pretrial release rates. For case dismissal, studies conducted in the Southeast and Southwest had significantly lower differences in case dismissal rates. For acquittal, for conviction, that's the next one that has significance. For conviction, studies in the Southeast and studies in the Southwest had significantly higher differences in conviction by attorney type. And for that last one, the sentence of incarceration, year was also significant. And so data collection year with differences in rates of incarceration slightly increasing in more recent years. So in more recent years, there was more differences in incarceration between attorney type. And additionally, in this one, studies conducted in the Southwest had higher differences in sentences of incarceration between counsel type. I also want to note real quickly here that all of these had high levels of heterogeneity, except for acquittal after we removed one outlier. So we did end up removing one effect size from the acquittal just because it reduced the heterogeneity from high to moderate. And then the next comparison was public defender versus assigned counsel. And we found, as you can see here, way less significant differences. So the only significant differences here were if the case was resolved by guilty plea and conviction, in that people with public defenders were more likely to resolve their case with guilty plea than people with assigned counsel. But people with public defenders were less likely to be convicted than people with assigned counsel, interestingly enough. There was, in terms of meta-regression, we weren't able to do as many meta-regressions with these comparisons because they had less studies included here, less effect sizes. But the ones that we were able to do meta-regression on, the only ones that were significant was in sentence of incarceration. The more recent years had lower differences in incarceration, which was different than what we saw with indigent defense counsel versus retained. And studies conducted in the Southwest had lower differences between counsel type. So I know that was a lot of information that I just threw at you, so I can try to sum it up a little nicer here. So basically, compared to people with retained counsel, indigent defendants were less likely to be released pre-trial, less likely to have their case dismissed, and less likely to be acquitted. But indigent defendants were more likely to resolve their case with guilty plea, more likely to be convicted, and more likely to receive a sentence of incarceration than people with retained counsel. In terms of comparing indigent defense counsel types, people with public defenders were more likely to resolve their case with guilty plea and less likely to be convicted than people with assigned counsel. And those effect sizes often varied by geographic region and sometimes varied by data collection years. So what all of this kind of led us to for our conclusions was that these discrepancies between outcomes are likely a function of systemic and individual biases rather than just attorney performance, which is what a lot of the legal literature had been focusing on and is focusing on up until this point. And so let me explain that a little bit more. So at the beginning, we talked about those believed mechanisms for outcomes by attorney type. But with those believed mechanisms, we would expect to see more differences between types of indigent defense counsel type. So the issues of high caseload and low pay experienced more by public defenders than by retained or assigned counsel. If this were what were driving these discrepancies in negative outcomes experienced by indigent defendants, we'd expect to see more differences between public defenders and assigned counsel, which we really didn't see a whole lot of. And then this other theory of familiarity bias or allegiance to the court due to courtroom work group. Again, we'd expect to see more differences between indigent defense counsel types, which we didn't see as much of. And so these systemic and individual biases that we're referring to, so with systemic biases, many criminal justice system practices are financially governed. So that, for example, like bail, fines and fees, even reliance on access to resources to attend scheduled court dates, inability to access these resources within these practices often results in consequential action. And so this is one way in which systemic biases might be kind of driving these more negative outcomes among indigent defendants. There's also potentially some biases in judicial decision-making here. So many of the outcomes in which indigent defendants experienced worse outcomes in this meta-analysis were resulting from judicial decisions. So pretrial release, conviction, sentence type are outcomes that are primarily decided by judges. And we do know from previous research that judicial decisions are often influenced by extra-legal and even subjective factors like race, gender, and socioeconomic status. And so here it's possible that these biases as a function of socioeconomic status are driving some of these outcomes, or also possible that indigent defense status alone may be enough to signal lower socioeconomic status and thus kind of trigger class biases within the system. The long-term impacts of these outcomes, so with incarceration at pretrial and at sentencing, the research shows beyond it being a removal of freedom, people who are incarcerated at any stage in court processing tend to have poor physical and mental health outcomes in the long term, tend to experience more economic strain. If you're incarcerated, you're likely to lose your job and other sources of income. They tend to have more impaired personal relationships, and incarceration often leads to continued re-involvement in the system. With conviction, there's a stigmatization of criminality, and having a conviction on your record, you now carry that stigma with you. It also can lead to strained social relationships, economic adversity, and again, poor mental and physical health outcomes. So this meta-analysis highlighted some areas that we can focus on for improvement. One is to interrupt this accumulation of disadvantage that happens in the criminal justice system. So we saw that indigent defendants were more likely to be detained pre-trial than people with retained counsel. And so this could mean that a lot of the outcomes that they experience later on in court processing could be stemming, at least in part, from that. We know in the research that people who are detained pre-trial are more likely to be convicted, more likely to take a guilty plea, more likely to receive sentences of incarceration. And so all of those were outcomes that indigent defendants in this meta-analysis were also experiencing. So it's possible that if we can interrupt the disadvantage there, that we can affect it further on down the line. And reforming bail practices may be one way to alleviate this disadvantage that indigent defendants experience, because bail practices are kind of financially and resource governed, which, as we said before, indigent defendants don't have as much resources as people with retained counsel. And then another area for improvement is to establish kind of more evidence-based standards for indigent defense systems and judicial decision-making across jurisdictions. And this was because the effect sizes in this meta consistently varied across geographic regions, which we weren't able to really dig into why it was varying so much across geographic region, if it was something to do with the social context or if it was the way that the indigent defense systems were set up. But either way, it's really just highlighting that there's these differences across jurisdictions, and we need to have more kind of standards that people can follow rather than just leaving it all out in the open. Some limitations I do want to highlight here. So like I said before, there was high heterogeneity and largely unexplained variance in effect sizes. I do want to say this is not uncommon in meta-analyses and observational studies, especially within the US criminal justice system, since we know that things vary across jurisdictions so much. But it does mean that these results, especially the one comparing indigent defense types, since those had especially high levels of heterogeneity, these should be interpreted with caution. There's also some inconsistency in outcome measurement across studies, and this was part of the reason, and reporting enough statistical information to include in meta-analyses. So studies that didn't report enough statistical information unfortunately got excluded, and that might have affected the results if we were able to include them. And the inconsistency in outcome measurement meant that in some instances we had to turn kind of continuous variables into maybe dichotomous variables, so we were able to compare them. But for some of the outcomes, it meant that we weren't really able to compare the outcomes at all because they were measured so differently that we weren't able to collapse them into something comparable. And then another limitation is inability to control for all the variables that can contribute to these examined outcomes. So that could be, I mean, I'll get into it more in the next slide, but that could be like demographic features of the people themselves. It could be case or charge severity, could be like rural versus urban areas, like all of these things that could have also contributed to these outcomes that we weren't able to measure in this meta-analysis. So future research, I think it would be especially helpful to focus on outcomes beyond just case disposition and incarceration, because those were the ones where we found kind of the most studies about, and these are very important outcomes, but to get a better understanding of what's happening throughout court processing, we need more research that's focusing on other areas beyond just these two. Also comparing outcomes across types of indigent defense counsel. We had a lot more studies that were comparing indigent to retained, but less so that we're comparing like public defenders to assigned counsel. So to understand kind of those nuances, we need more studies comparing outcomes across types of indigent defense counsel. And then also examining outcomes across different case characteristics. So felony or misdemeanor, how many, like the number of charges they got, what kind of criminal history people might have. Things like this can also be impacting these outcomes, and we weren't able to include this in this meta-analysis just because most studies didn't include this information, and so we couldn't include it as a moderator here. And then also examining the mechanisms for discrepancies experienced by indigent defendants compared to those with retained counsel. So a deeper dive into these jurisdictional differences that are driving these differences. And then also looking at the intersectionality of people with indigent defense status. So it could be possible that there's research that suggests that people of color are more likely to be represented by public defenders. And so is it possible that a lot of these outcomes are being driven by racial biases that we weren't able to examine in this study, or other groups like people who are disabled or other marginalized groups that might be kind of driving some of these outcomes? And that is what I've got for you all today. So I will open it up for questions. I can see some stuff in the chat, but thank you all for listening. Yeah, excited to hear what you guys think, any questions you have.
Go ahead, Sarah. If you can read the ones in the chat, how about you just respond? I know that Bill Cox's question came in right as you were discussing that issue about the consequences of the fact that indigent defendants were more likely to be denied bail, and that might have a cascading consequence. And I think that's perhaps the context in which Bill was asking his question.
Yes, yeah. So we weren't able to control for that because the studies that they mostly, if they looked at like case outcomes beyond pretrial detainment, they weren't including that as a control that we could use. Or if they did look at pretrial and case disposition, they weren't indicating who was detained and who wasn't. They were just kind of describing the trends. So we weren't able to control for that, but it is very possible that that's what's driving a lot of the outcomes in the study. And then for the pooled odds ratios, does the difference of 1.3 mean? Yes, 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 that's exactly right. So 103% more likely, or 1.3 times more likely. That's, yes, exactly how you can interpret it.
Let's go to Paul.
Yeah, hi. Thanks so much for the presentation. I really appreciated it. I was curious, did you look at caseloads at all of private attorneys versus public defenders. And I asked that specifically because while I also agree that I think prosecutors oftentimes offer better pleas to people with financially sustainable more options, we do see from the process side, our public defenders have much higher caseloads, so they're consistently asking prosecutors for pleas every day, day on, day out. And just as we all know as human beings, if you see the same person every day, you're likely to just feel, like you want to say no every once in a while, versus the private attorneys who have smaller caseloads. And I'm curious if you considered that at all in your research.
That's a really good point. And that could be why when we saw the comparison between people with public defenders and people with assigned counsel, people with public defenders were more likely to resolve their case with guilty plea rather than by like going to trial. And so that could be one of the reasons why is you're speaking to like high caseloads and kind of that courtroom work group relationship. And that could be why we see the differences between public defenders and assigned counsel with guilty plea deals. But in terms of looking at caseload specifically, I don't think we saw any studies that use that as like a control variable in their analyses, interestingly enough. The studies that I found on caseloads were kind of independent of the outcome studies. So looking at a study that examined both of those might be really informative.
Okay, anyone else who has questions, please do stick your hand up. I know I have a couple, if I may, Sarah. I actually don't know much about meta-analytic techniques, and so this might, for that reason, Bill's question spoke to me. I don't know how you deal with the fact that most of these findings, they obviously come from studies where there's been some sort of regression analysis done or an attempt to control for covariates. And I assume that what you're taking is the effect sizes from those individual, variables of interest. How is it important? Obviously I don't understand, and I know there was a lot of methods you skipped over. I don't understand how you deal with the fact that every single one of those regressions will have control for different stuff in producing the effect sizes that then you use. And I also don't understand if that means you're able or unable to sort of talk about, how much the effect, the conclusion that you have, sort of how reliable it is depending on whether people control for the right stuff in the first place. Can you speak to any of that? Sorry, it's so vague.
Yeah, no, absolutely. So some of the studies that we included did already calculate their effect sizes of either like regression or calculating an odds ratio or a chi-square. And so some of them did have covariates they controlled for, but not all of them. And so we couldn't definitively say when we pooled them together that these things were being controlled for, because a lot of the ones that did do regressions, they did control for things like charge type or charge severity. But there were other studies where the only things we had to work with were frequencies of like the number of people detained versus released pretrial, stuff like that. And so for those ones, nothing was controlled for because it was just like raw numbers of people. And so because of that, we didn't really want to say one way or the other that things were being controlled for. But I will say the ones that did do some sort of regression that we could include, charge severity was almost always included as a covariate. So I'd say if anything was controlled for as much as it could be in these studies, that would be one thing. But I think it was maybe like 50-50 split on whether we could include something that had been like a regression or a chi-square analyses versus something that was just like raw frequencies.
Right. So is the implication of that when you find something in your results, a relationship between X and Y, it's really just essentially an accumulation of evidence that on a bivariate level, there appears to be such a relationship. And so when you find relationships that may indeed be confounded, like the bail thing and everything else, or the guilty pleas and the acquittals or something like that, that's because those are bivariate, coexisting, and logical.
Mm-hmm.
Okay, thank you.
And I see the question about criminal history as well. And surprisingly, that wasn't as controlled for. There were some studies that included some sort of measure of criminal history. I think some of them were just kind of like a binary yes or no. Did the person have a criminal history or not? And some of them were like number of prior convictions, but the vast majority of studies we included did not control for criminal history for whatever reason. Which I do know in my own experience with doing this research, and maybe y'all can speak to this too, criminal history can be kind of a sticky one to try to measure, depending on the kind of data that you've been given. If you've only been given data for a certain time frame, you can't necessarily backtrack and see what a person's entire criminal history is. So that might be one of the reasons why we don't see it pop up a lot yet. The other thing I'll say too is another thing we noticed doing this, since this data covered so many years, 1962 to 2016, statistical methods have changed over the years. And so a lot of the earlier studies are where we were just getting kind of those raw frequencies because they either didn't report the full statistical information for a regression or just didn't do a regression, whereas the ones that were done more recently are the ones that we were able to kind of pull in studies that had covariates and had controlled for things.
So just to follow up, does it follow that because there was only a few cases where there was like meaningful differences across years, that those controlled for, those things becoming more and more controlled for didn't have a large effect on the effect that was observed? Is that a fair thing to say, or?
I think that's yeah, something that we could infer, especially because the ones that did vary by data collection year, I have to go back and double check, but I think incarceration was one that varied a lot by data collection year, which would make sense because decision to incarcerate is heavily affected by other aspects beyond just like the case at hand. So yeah, I think it'd be fair to say that for the ones where it did vary across data collection years, that might be where the covariates are making a bigger difference. But the ones where it didn't, maybe that means that it's being controlled for adequately anyways in the previous studies, even if they were only reporting raw frequencies.
I want to urge folks to continue to raise your hand. I don't mind telling everybody that I told Sarah that it was in 2014 that I was speaking with a colleague and said somebody has to do a meta-analysis of this literature, and I'm just delighted to see it done. I mean, this is so valuable. And I don't know if I told you this, Sarah, but I mean, even recently a journal asked me to sort of review an article that compared attorney types on case outcomes, and it was just yet another one to the pile, and it was kind of discouraging because there's this ambiguity in the literature, right? There are some really well done studies that don't show differences between these kinds of attorneys. So to have this kind of clarity is really, truly path-breaking, I think, for us. I have more questions, but I really want to make space and make sure everybody else. Paul, go ahead.
No, I was actually just going to echo what you were saying, Andrew, that I do think that this is extremely important and can see where this can really bring value for policy decisions. Just thinking about Arizona right now and being able to show this type of data really supports it. So I just wanted to echo what you were saying. Sorry. I will try to think of another question. My brain is going a million miles right now on this. So
I did include my contact information here. So if anything comes up later on, I mean, since this was my dissertation, I'm always happy to talk more about it. So feel free to reach out.
I do. I have another kind of follow-up question. So you said there's very high levels of heterogeneity, which is not surprising at all to me in this domain. But you also said it's not an atypical level of heterogeneity, at least in this subsection of observational studies. It seems to me that unless you're controlling for individual courts, I would kind of expect it to be especially heterogeneous, just because so much is dependent on what judge happens to be presiding. And I think not only not even just is one judge harsher than the other, but the way a particular judge reacts to public defense clients versus privately retained clients. I think it's very likely that there are significant differences across judges. Can you speak to that at all? Is it especially heterogeneous compared to observational studies in general, just not criminal justice studies, because they would kind of have that same issue? Or yeah, I guess, can you speak to the particularities of how diverse this sample is, essentially, I guess?
Yeah, I think you're spot on with saying that it's very expected, especially in kind of criminal justice related research, with all the different variables that can impact even just like jurisdictional differences, but also, like you said, just like whoever the judge is in that case that day. And so in observational studies, there's high heterogeneity in general, just because you can't control for all the things you can in like a clinical trial. But in criminal justice studies, especially, when I was first doing this and kind of saw the high levels of heterogeneity, there was some initial concern, because all of the like meta-analyses guidelines will usually say if you find high heterogeneity, you should fix it and not report those results. But when I did more digging and found other meta-analyses on criminal justice related topics, like I think I found one about like treatment availability in jails and prisons and stuff like that. It was high heterogeneity across the board. Every single study I found that was done with criminal justice data. So I think it's pretty to be expected in this field. And I'm not sure that we'll see that kind of resolved anytime soon, unless we find a way to like really systematically measure these things across different areas and control for all these different things. I think it's pretty expected that we'll keep seeing high levels of heterogeneity.
I am curious, when you talked about the result outcomes, did you consider at all, and maybe you did, and I just was not paying full enough attention during it, but the post-conviction result outcomes, did you look at that at all, and how that varied based upon private and public?
Can you repeat that? The what?
Yeah, so post-conviction, so if they were actually sentenced, did you look at the outcome results at all for post-conviction relief for public defender versus privately appointed contractors?
Actually, I don't know that we saw any studies included about that. We had like the initial sentencing decision of whether they were incarcerated or not. And then in like the post-case outcomes, there was stuff around recidivism and appeals, but we didn't find anything about like people being like paroled or released early or anything like that. If that's what I think it sounds like you're referring to.
Anybody else? I've got some teed up, so nobody talks. I'm just going to talk. Sarah, I'm going to ask two at once. Oh, sorry. Is that indeed Bill Cox?
No, it's not. I'm not sure why I'm
I didn't think it was
identified as Bill Cox. I think maybe Bill Cox put the invitation to this presentation in the TIDC calendar, and I clicked on it, and so I guess I'm Bill Cox now too. I'm actually Scott Ehlers at the Texas Indigent Defense Commission. My question is really very basic. Can we get a copy of the research, and does the copy include a listing of both the research that was included and the meta-analysis, and research that was not included? Because it just sounds like an awesome list to be able to tap into to look at the history of indigent defense research. And so I'm kind of a indigent defense history buff as well. So would love to see that. Besides that, just in terms of the description of the variations in research, and I guess that's what you mean by heterogeneity, that there's a wide variation in terms of, you know, what kind of variables are included, or, you know, what's controlled for, or regression versus not regression. Is that what heterogeneity means?
So in this context, heterogeneity is referring to the individual effect sizes of each of the studies. And so I should have had like a picture queued up to show, but basically for for each one, the software that I plug it into will give me this kind of graph and also the like statistical numbers, but the graph is what kind of visually helps me see it, that shows what the pooled effect size was and then where all of the effect sizes are falling around that. And so high levels of heterogeneity means that those effect sizes are falling kind of like all over the place around the pooled one. So in some instances, it meant that there was stuff on both sides of the pooled effect size. So like some of them were higher, some of them were lower, or some of them, it might have meant that there was like a few outliers that like most of them were around it, but then there was like one or two that were way off in other places. And so in the full dissertation, which I can absolutely send around, and hopefully there will be a published version soon that's a little more digestible to read than the dissertation. But in that, I include those plots for each of them, so you can kind of see for each study where their individual effect size was falling compared to the pooled effect size. And when you look at that, if you really want to get deep into it, you can also look at kind of where these studies were coming from, and if there's like consistency in like where the location is and how far off from the pooled effect size those are. Can also look at like the data collection year that it was and if that's affecting it, which the meta regression did kind of help explain why they were falling away from, why there was kind of those high levels of variance. But if you were interested in kind of visually checking it out and seeing why some of them were farther away, that's one way that you could look at it. And in the dissertation, I do include the full list of the 40 studies that were included in the meta-analysis. I didn't include the full 71 studies in that, but I do have that list and would be happy to share it. I just have to format it a little because it's just kind of in a chaotic Excel spreadsheet right now, but I could put that into like a Word doc and I'd be happy to share it around.
Cool, great. I guess the last thing, I mean, just from your description, I mean, I'm hearing what I would consider to be like a lot of problems with some of these analyses. I mean, if they're generally not controlling for criminal history of the defendants and comparing defendants with similar criminal histories, then I think that's invalid. If you are not controlling for whether or not someone is detained pre-trial versus out of custody and what the results are in their case, then I mean I find that to be a highly problematic analysis. And so I don't know if you dug down a little further. I mean, this is obviously a huge amount of work. So I wouldn't be surprised if you didn't, but I would be interested to see like, okay, in those studies in which, you know, they did control for criminal history or there was a match of defendants for criminal history, or they controlled for pretrial detention versus out of custody, like here were the results from that, like, I guess, mini meta-analysis.
We could have done that. We didn't. Time constraints and just bandwidth issues. But we do have that information of what was controlled and what was just kind of frequencies. It would be, I'm not sure that there would be enough that did consistently control for the same things to do their own meta-analysis of those, because at least the way we did it, we wanted at least like 5 independent effect sizes to include for an outcome for a meta-analysis. And I think it might only be maybe like 1 or 2 of them that had enough that were using consistent covariates that we could do a mini meta-analysis with them, which is what I think, like as a field of research, we can start doing moving forward to improve, is if we get more of these studies that are using these more rigorous statistical methods, then maybe in a few years we can do another meta-analysis that is much more explanatory of why we see these different outcomes. And if it's because of things like criminal history, charge severity, or other things that's going on that we really weren't able to dig into here.
Great. Thanks.
Sarah, can I just pop in with one last one here? So, I mean, I have one small one, which is I'm actually wondering how you dealt with unrepresented people, because I mean, I'm really interested in that comparison. I know you didn't examine it, but I wonder if they showed up in your studies a bit. But I also have this other like sort of policy implications question. As I look at the literature, and there's some literature that says, you know, public defenders do worse, and there's some literature that says public defenders don't do any worse. And there's even some literature that says public defenders do better. And the implications of each of those, depending on the theories, and you review the theories a little bit, are kind of different, right? Because some of them suggest if you give public defenders more money, they'll be better. Some of them suggest that actually public defenders are just part of the court architecture, and it doesn't matter how much you fund them, it's all about the interactions between the people. In the indigent defense field, a lot of people in the policy advocacy sort of arena are really concerned to improve these services. So given that you've now found like fairly consistent evidence that actually indigent defense clients are getting worse outcomes, what do you think that means the solution is? Are you able to choose between these different interpretations and sort of suggest what we should do policy-wise?
Yeah, so to answer your first question, we did consider using a no counsel comparison group, but we didn't find enough studies that included that kind of comparison to include in the meta. I can't remember the exact numbers. I had them written in one of the notes on my slides, but it was something like only 8 studies across all of the outcomes included comparison to a no attorney group that we could have used. So we ended up excluding it for that reason, just because it didn't seem like we had enough there. For policy implications, I mean, I think the funding issue is always a big issue, and I don't think I've ever talked to an indigent defense service group that isn't underfunded and needs more funding, and so I think that's definitely one policy area that most areas do still need to be focusing on, of increased funding, getting more public defenders so that there's not so much high caseload issues. But I do think that another thing that we've been kind of working on is as a group, as an advocacy group, is like getting rid of these financially based systems in the criminal court system. Like so many things that require people to have some sort of like financial resources, or something like bail, like fines, like even just getting to scheduled court dates, so many of these things that are financially governed, that it's hard to, at least in this meta-analysis, I think it's hard to tease out how those things are also impacting these court cases beyond just attorney type, because we are working with a population that is, like, by definition financially disadvantaged. So how are all of these financially governed practices in the criminal justice system also impacting these negative court outcomes?
Right, thank you. Well, I see Elisa has had to drop off. Does anybody have any passing words for Sarah? Or Sarah, do you for the group? Anything you'd like to just put a bigger flag on?
I mean, I'm psyched that I got to present to you all today. This was great. I'm so glad I got to hear y'all's thoughts and everything, because hearing the thoughts from the people that are actually like doing this work and out there like on the front lines is really helpful. And I'm looking forward to how this research continues to grow and this field of research continues to grow, and how we can improve it from a lot of the research that we saw from 60s, 70s, 80s, 90s that isn't what we can do now with the research and the resources we have now.
Thank you so much. It was great. Look forward to the next one.
Awesome.
Yeah, thanks.
Yeah. Thanks, Sarah. I see Paul already told you have another PhD to do, so there's that.
Yeah, I don't know if I could do it again.
Awesome. Well, thanks, everybody. Stay in touch. We'll see you next month. Bye-bye.
Bye.